Hey guys, what's up? It's Debbie, and we are back with the Amber Alert murder trial, New Hampshire v. Dustin Duren. Hey guys, say hi to everyone. Let's see who's here. Hey Judy. Hey Carla. Hey Nancy. Hey Marty. Let's see what Judy's trivia is for today. The defense only listed 5 people as witnesses on their witness list. However, they may recall any of the prosecution witnesses per court filing of October 3rd. On October 22nd, the defense filed a memorandum on kidnapping, arguing the meaning of the word kidnapping. In summary, the defense argues that parents can kidnap their own children. The defense argues that parents can kidnap their own children. Yeah, like he did. Thank you, Carla. Well, you're here, Marty. Hey, Michelle. Oh, that's right. I think we have Cross still to go on the cop that did the interrogation.
And Attorney Kettle's ready to proceed?
Yes, Your Honor.
Detective Sergeant, you're still under oath, sir.
Yes, sir.
Thank you.
Detective Sergeant, I'm going to back us up a little bit and just go through in some bite-sized chunks, okay?
Okay.
So we were talking about the incident itself, what Dustin told you about the incident. He said it happened super fast.
Yes.
He said, there was, again, it was like training to where it was, he said, there was, again, it was like training.
Yes.
He said, to where it was just grabbed it, cocked, grabbed Elwyn, and then right when I shot, it was just immediately I grabbed Elwyn and ran out of the house.
To the car.
Yes, I'm doing it bite-sized chunks here. Yes.
Okay. Yes.
And just immediately ran out of the house and put her in the car.
Yes.
He said after he put her in the car, he sat for a minute talking to Elwyn.
Yes.
He was making sure that nothing had happened to her.
Correct.
He was checking to make sure she didn't have injuries.
Yes.
She didn't.
Correct.
He loaded the car up.
Yes.
He got the kids in the car.
Yes.
He was thinking, at some point I'm going to turn myself in.
Yes.
But first he was going to spend some time with his kids.
Mm-hmm. Correct.
He said he drove to Concord.
Yes.
Once he got to Concord, he sat with Elwyn and Valen again.
Yes.
And at that point, they were both good and they were happy.
Yes.
He called his mom and told her what had happened.
Yes.
And he told her to call the cops.
Probably should call the cops is my recollection, but something to that effect, yes.
He told his mom he was going to turn himself in.
I believe so, yes.
He told her he wanted some time with the kids beforehand.
Yes.
He told you that after he talked to his mom, he turned his phone off.
Correct. Went dark, I believe is what he said.
He said went dark, and he said, I turned my phone off.
Yes.
He said he drove to somewhere in New York State.
He believed it was New York State. Yes.
He and the kids got a few hours sleep.
Correct.
He woke up and initially thought, well, I'll just surrender at a random police department.
Yes.
But then he decided he should probably do it in New Hampshire.
Correct.
And by do it, he was referring to surrendering or turning himself in.
Yes.
So then he started.
Hi, Carla.
Yes.
He decided to go to Concord and then just
I
surrender
thought you
there,
said he was a sexy
That was his
daddy,
plan, yes.
Nancy.
but he wanted to just sit down with the girls and just have breakfast somewhere.
Yes.
Just a couple more questions on what Dustin said in relation to his training. Dustin said everything was so fast. It really was like training. It was instant.
Referring to his marksmanship training, yes.
He said it was like muscle memory.
He did say that.
He said it was his training coming out.
He did say that, yes.
One moment. No further questions.
Because you love me, Marty.
Sergeant McLaughlin, just two questions. How many police stations or police barracks are in Keene?
So there's a state police barracks in Keene, so that's one. The Keene Police Department is two, and the Cheshire County Sheriff's Department is in Keene as well, so that's three.
And to the location where he was originally stopped by, or initially stopped by police, he passed right by your barracks, is that correct?
He even commented that he saw the sign for the state police barracks.
And he avoided that.
Yes,
Now, how many police stations between Keene and Concord?
a lot. You don't expect me to know how many, do you?
No, that
Okay,
many, right?
a lot.
You can't even judge.
And even from the Vermont border into New Hampshire, there's at least Chesterfield Police Department.
Okay. Did the defendant talk to you about whether he had a connection to Concord, New Hampshire?
No,
Now, everything in the defendant's statement, all of the words that he provided to you, that's what he told you, correct?
that's correct.
Anybody else tell you those words?
No.
No other questions?
Recross?
No, Your Honor.
Okay, thank you. Can Detective Sergeant McLaughlin be excused?
Yes, Your Honor.
Okay, thank you.
Thank you, Ron.
Your Honor, may I approach the monitor?
Sure.
Your Honor, at this time, the state has no further witnesses and we would rest.
Okay. All right, thank you. Okay, members of the jury, at this time, I know that we just started for the day, but we are going to be taking a break at this point. So I'm going to request again that you retire to the deliberation room. Please do not discuss any aspect of the case. Do not discuss it with any other member of the jury. If anybody does that, please report that to a court security officer. And thank you, and we'll resume as soon as we can, okay? All rise.
You're gonna do JOA now?
No rational trier of fact could find beyond a reasonable doubt the state has disproved the affirmative defense of others, and therefore the court must dismiss all 4 charges. Specifically, Dustin was justified when he shot Caitlyn, and all charges must be dismissed. The state offered evidence that Caitlyn died from a gunshot wound to the head, and that the gun that was shot was Dustin's, and was found in Dustin's car upon arrest. However, the state introduced the defendant's own statements through Detective McLaughlin, which offer enough evidence of justification, and so the burden shifts to the state to prove it was not justified. Dustin told the state in his interview how and why he was justified. Specifically, he described Caitlyn refusing to leave his home. He said Caitlyn was getting more and more aggressive. Caitlyn told him she was going to take the kids away from him. Caitlyn told him she was going to call the cops and have him arrested. Caitlyn grabbed Elwyn and was not letting go. She was again threatening to take the kids. Caitlyn was saying she was going to take Valen and Elwyn back to Minnesota. Dustin tried to grab Elwyn and be like, hey, let go of Elwyn. And Caitlyn just wouldn't let go. Caitlyn had Elwyn in a bear hug, a 2-handed bear hug. Dustin tried to grab Elwyn a couple of times. He couldn't pull that much because he did not want to hurt Elwyn. Elwyn was yelling. Elwyn was crying. Caitlyn was holding Elwyn forcefully enough to cause her to cry. Dustin said he grabbed the gun, chambered it, and while grabbing Elwyn, pulled her back and shot. He said it was immediate. He said it was super fast. He said, right when I shot, it was just immediately I grabbed Elwyn. Dustin said everything was so fast, it really was like finger snapping, training. It was instant. He said it was like muscle memory. It was his training coming out. He said right when he shot, he grabbed Elwyn, ran out of the house, put her in the car. He sat for a minute talking to Elwyn. He said he was making sure that nothing had happened to her. He said he was checking to make sure she didn't have injuries. He said she did it. He loaded the car up, got the kids in the car. He was thinking at some point I'm going to turn myself in, but first he was going to spend some time with his kids, and he drove toward Concord. New Hampshire 627-4, paragraph 2 says, a person is justified in using unlawful, deadly force against another person under 4 separate circumstances. And the defense argues that 3 of those 4 are applicable here. When he reasonably believes that such person is B, likely to use any unlawful deadly force against a person present while committing or attempting to commit a burglary. C, is committing or about to commit a kidnapping. Or D, is likely to use any unlawful force in the commission of a felony against the actor within the actor's dwelling. So here, paragraph B is met. Caitlyn used force against Elwyn when she restrained Elwyn in her arms while committing a burglary. She entered, or it remained unlawfully, in the building or occupied structure. She did not leave Dustin's apartment when he asked her multiple times.
Thank you for the super chat, Nancy.
She had the purpose to commit a crime.
I better not. He didn't do anything.
To remain
Not yet, anyway.
attempting to commit a number of crimes the court could find. Kidnapping or 633-4 interference with custody. A person is guilty of a Class B felony if such person knowingly takes from the state or attempted interference with custody, attempts to take from this state or entices away from this state any child under the age of 18 or causes any such child to be taken from the state with the intent to detain or conceal such child from a parent. Caitlyn was threatening to do so. She was attempting to do so. She was refusing to leave the home or release Elwyn. Or the purpose to commit false imprisonment, or the purpose to commit false report to law enforcement by telling the police that Dustin did not have permission to bring Elwyn to Minnesota, or to
harassment with a purpose to annoy or alarm another, communicates any matter containing or any threat to kidnap any person or to commit a violation of interference with custody. Stalking, purposely, knowingly, or recklessly engage in a course of conduct targeted at a specific person, which would cause a reasonable person to fear for his personal safety or the safety of a member of that person's immediate family, and the person is actually placed in such fear. In the course of conduct would be restraining and yanking back element. Theft by extortion. A person is guilty of theft as he obtains or she obtains or exercises control of the property of another by extortion and with a purpose to deprive him thereof. As used in section 2, extortion occurs when a person threatens to A, cause physical harm in the future to the person threatened or to any other person or to property at any
Are the mics at the table even on? Because they're there. I see one.
or any other person to physical confinement or restraint. Attempting to obtain Dustin's money, extortion would be confining element. Theft by deception. A person commits theft if he obtains or exercises deception occurs when a person purposely creates or reinforces an impression which is false, in which that person does not believe to be true. Attempting to obtain Dustin's money, deception would be telling Berlin PD that he took Ellen without permission. So those are all under paragraph B, where she was committing a burglary. Paragraph C is also met, where the evidence shows she was committing or about to commit kidnapping. Dustin told the investigators when she said she was taking the kids back to Minnesota to take them away from him. Evidence shows that she was about to commit a kidnapping by her behavior and her words. And paragraph D is met, where here Caitlyn
Oh, that's right.
force against Elwyn when she was restraining her in her arms, squeezing her while attempting to commit interference with
They
custody.
need the ones that make amplification.
So,
Whatever that word is.
she was attempting to commit a felony
Amplification.
offense
I can speak.
using unlawful force. If the court agrees with those above arguments, it can still consider the crimes of reckless conduct and endangering the welfare of a child. And the state has not provided sufficient evidence for a rational trier of fact to find guilt beyond a reasonable doubt with respect to either of those charges. Reckless conduct alleges that Mr. Duren recklessly engaged in conduct which placed another Elwyn in danger of serious bodily injury by shooting Caitlyn while holding Elwyn. 2 reasons the court must dismiss for insufficient evidence. 1, the facts don't show beyond a reasonable doubt that Dustin was holding Elwyn while shooting Caitlyn. The only evidence the state presented is what Dustin told Sergeant McLaughlin and what Dustin said. Right when I shot, it was just immediately I grabbed Elwyn. He grabbed the gun, chambered it, grabbed Elwyn, pulled her back out of the way, and shot. The state alleges that this action was reckless, even though we have also heard from McLaughlin's interview of Dustin that he is an accomplished marksman, a Marine, that he's won awards for his proficient shooting. He knows how to use a gun. There was no evidence he was impaired, that he was using the gun recklessly around Elwyn, that he pointed the gun at Elwyn. The state, in its opening, focused on the statement that his acts were deliberate. Dustin carefully aimed the firearm. He purposely pulled Elwyn out of the way. He made sure that she was not at risk. He aimed the firearm away from her. We heard that the gun he used has many
The sound of the gun, though.
accidentally discharged. In terms of the risk to Elwyn,
He could have deafened her.
no different than if Dustin and a child were at a firing range and Dustin fired not towards the child but instead at a target. That would not be reckless. The presence of a child in the same general area that a gun that is fired is not without more.
I don't know why the subtitles look like that.
At or near her rise to reckless conduct. And third, for the endangering welfare of a child complaint, Your Honor,
Hey, Carla.
the conduct or the evidence that the court has heard feels bad, but what the state alleges didn't happen, and what did happen is not a crime. In Ray and
I don't know why the redirect only works half the time.
169 New Hampshire 546.
It's like notifications.
Defines
They work when they want to work.
endangering welfare of a child means a person is guilty of endangering the welfare of a child protection or support he owes to such child. So the state's required to prove two things: that Dustin knowingly endangered the welfare of Ellen, and two, that he did so purposely by violating a duty of care owed to her. And so again, the evidence here is that Dustin grabbed Ellen from Caitlyn and moved her out of the way while simultaneously firing one bullet in Caitlyn's head. He said, "Right when I shot, it was just immediately I grabbed Ellen." He did not violate a duty of care. He acted out his duty to care, to save her from harm, to remove her from the situation.
And what if she had moved real quick
There's no evidence she
out of his,
Ellen was in danger.
however he was holding her? Like, what if she had jumped back in front of her mom real quick? He could have just shot her.
Engaged in behavior creating an actual
It was stupid.
of injury to a child's welfare. The state didn't offer evidence of welfare, but beyond harm to the ear. So there was no evidence that there was any potential psychological harm or anything of that nature. There was no evidence that she was injured. She was complaining of her ear hurting. The doctor told us her pain was secondary to lateral noises. There was no evidence of perforated eardrum or trauma to the ear. There was no outward signs of trauma. Ellen appeared well-kept and
No
nourished.
outside signs of trauma, but she's got mental trauma she's gonna have for the rest of her life.
Produced from the gunshot.
And I can say that from experience because of my husband.
Pressure it takes to pull a trigger.
He was 5 when his mom died. And he didn't see it happen, he heard it happen, and he still has trauma from it.
Still is when it's fired. And that's no different, Your Honor, I would argue, that when you take a child to a musical festival with loud music without ear protection. And also, as we know from the evidence that Sergeant McLaughlin provided on direct and again on cross, is that Dustin said, "I can see where this is going, of like, could it be that I'm endangering Ellen by what I did?" And I would very much say no. And then Sergeant McLaughlin responded, "Yeah, just to kind of tighten that up a little bit more, you're an expert marksman of some sort in competition. So it's fair to say you knew you weren't endangering Ellen." And
I haven't even told him about this case.
yes, I was not endangering Ellen.
And sometimes I don't pay attention and I tell him stuff and it's too close to home and he'll be like, just like my mom. And then I'm like, oh crap, I should have told him about it.
Both knowingly endangering the welfare of a child and purposely violating a duty of care. Thank you.
Yeah, they were outside arguing. And then his dad came inside and realized that Travis was awake. And he said, he had Travis go get him a blanket to wrap her up in. And it was a red blanket. And so his favorite color is red. I guess because he associates it with his mom because of the red blanket.
The defense argued that there has been evidence
He was 5.
presented of self-defense through the defendant's statement.
He thinks that he strangled her.
Assuming that to be true, but I would state for the record.
But he didn't see it. He just heard it.
His statement established that he told Sergeant McLaughlin that he killed Caitlyn Naffziger very deliberately, that he did so because she refused to leave his apartment, that he did so after...
Yeah, I feel bad for him too. Because he has no idea where his mom is. Like, he doesn't have a grave to go put flowers on or anything.
Caitlyn made the day of the murder, that she was going to take the kids away from him, she was going to call the police, are things that were new to
And then when the police
by his own testimony, she had said similar...
first, I mean, the police questioned his dad over the years, different times. And he never said I didn't do it. He just said you can't prove it. And then when his daughter from his second marriage asked him, he said there's lots of places in Florida to hide a body.
Drive them to her aunt Brenda's house. He was in the
So we'll never know where she is or what happened to her.
He put Valen in the car seat and got her ready to go. He was trying to take Elwyn so that he could do the same thing, so he could get her into the car and get Caitlyn moving. Caitlyn refused to let Elwyn go, and she refused to leave. The clear import of the defendant's statements was that was why he killed her.
Yep.
And so, just for purposes of the record, I don't think this is disputed.
And when Travis told me about it, he goes, "Now are you gonna run?" Because we were still, it's when we were dating.
Each element of those offenses, that the defendant caused Ms. Naffziger's death, and that he did so knowingly.
And I was like, "No, why would I run?" He said, "Everybody else has." And I was like, "Oh my God." So yeah, he's got a lot of mental baggage, I guess you could say. I don't either, Nichelle, because they're not, in my mind, they're not there. So, but I would just like the thought of having a place to go visit. Do you know what I mean? I know it's weird. Like, I never go to visit my parents' grave sites, but I know where they are. Like, I know where their bodies are. It's comforting to know where their bodies are. Oh, thank you, Nancy. But I don't go visit, but I like to know that their bodies are there. That they're not just randomly, who knows where, like with his mom,
That is the case. There is sufficient evidence at this stage in the light most favorable to the state.
It's just, it's eerie not knowing. Yeah, someday you will. But like, it's eerie not knowing where your loved one is.
At 307, it's a 2015 case. At the sufficiency stage, the defendant must establish that no rational trier of fact, viewing all evidence and reasonable inferences
Yeah. Yeah. They're not there. So why go there? But there are some people that like to go to graves and sit down and talk through their problems or whatever. So,
I would submit that there is certainly sufficient evidence.
oh, she was cremated? See, now if you cremate someone and have an urn and have them in your house, you know where they are. That's, you know.
I'll talk now, I'll refer now to the facts. The defendant must
Yeah.
and reasonably believe.
It's just like you don't know where she is, And the way he did it was right before Christmas, and he set it up like she had gone Christmas shopping and was kidnapped. He set it up to look like a kidnapping.
The facts here show the defendant did not believe he was acting in self-defense. The defendant shot and killed Caitlyn. He then packed up several days' worth of clothes, got in his car, and began driving. He certainly told Sergeant McLaughlin, "My plan all along was to turn myself in." He never, in fact, turned himself in. He was arrested at gunpoint and pulled out of his car. The defendant spoke for 2 hours, as we saw, with Sergeant McLaughlin. At no point in that statement did the defendant tell Sergeant McLaughlin, "I acted in self-defense." At no point did he tell Sergeant McLaughlin, "I did what I had to do. I didn't want to kill Caitlyn.
I sometimes get feelings
Words to that effect.
like when I do something that my mom or dad would be proud of me.
You say anything indicating he
Like when I went to Venezuela on a missions trip with church, I got the feeling that my mom would have been proud of me.
the defendant himself did not believe it, and that's
But other than that,
certainly in my most favorable.
like I don't go to their graves or anything like that.
There is
Oh, cool.
necessary to use deadly force to defend himself.
That's neat, Judy.
The defendant told Sergeant McLaughlin when asked that Caitlyn did
Oh, that's cool, Marty.
not threaten Elwyn physically. No physical harm threatened. The defendant's actions, I think, further, beyond what he told the police, when he had an opportunity to tell them why he did what he did, and failed to say that he acted in defense.
What I wanted to do when I died is not legal, so I guess I'm not gonna do it. I wanted to be cremated, and I wanted my ashes put in the Seven Seas Lagoon at Walt Disney World, but that's illegal.
I had to do it. He didn't tell his mother she was going to kill
People
him.
still do it though.
I shot Caitlyn, or was to that effect, you should probably call the cops. In the light most favorable to the state, those are not the words of someone who believes that they have used deadly force in a justified manner.
I know what he's gonna rule. I don't know why we're sitting here listening to something we can't hear.
The various forms of kidnapping, I'll put this on the record, Your Honor, under State versus Monroe, and I don't have.
I had a friend, actually, I lost touch with her. She's probably gone now because she was quite a bit older than me.
73 New Hampshire 469.
She lived in Connecticut.
The defendant not only must
She
provide
wanted
actual notice of defense,
she wanted to be cremated and wanted her
but there also
ashes. There's a company somewhere,
location of or sufficient
I don't know if they're still in business,
supporting defenses.
that would put your ashes in fireworks, and then you could have your ashes shot off in fireworks.
Walking through each of the
Aw,
ways
that's sweet.
27-4, starting first with 2A. I addressed that
Oh, that's cool too, Nichelle.
because he reasonably or actually believed it was necessary to prevent the use of deadly force against himself or anyone else. He told the detectives that. 627-4-2B.
Oh, that's cool too, Judy.
Presented this court with a variety of crimes they claim that Caitlyn could have committed or had the purpose to commit when she unlawfully remained inside of Mr. Duren's home.
I wanted to be buried next to my mom and dad, but my stupid stepmother bought the last plot next to my dad. So my dad is buried between his two wives
I'm not going
in my family cemetery.
those crimes. I don't think
My family cemetery. We have one little section that's all us.
certainly not in the light most favorable to the state at this
She has an ex-husband that she had kids with. She should be buried over there.
to show that the defendant did not actually believe Caitlyn was committing a burglary, that he shot and killed her by shooting her in the head because he actually and reasonably believed that Caitlyn was
Aww,
had purpose to commit theft.
that's cool. We had our honeymoon at Disney, so
Along those lines. So
I
at this stage,
Travis doesn't want to be cremated. He wants us to be buried side by side somewhere.
here,
I got to pick a new cemetery now. Well, I don't have to pick a whole new cemetery. I don't have to pick a whole new cemetery. Just a different part of it because our little section is full now.
2D, 627.
Hey, Wiggles.
Defense counsel misstated the law. Defense counsel stated that under 627-4-2D, well, I'll state, the law says that a person is justified in using deadly force upon another when they reasonably believe that a person is likely to use any unlawful force in the commission of a felony against the actor. While inside the actor's dwelling. The actor in this case is the defendant. So what that law actually says is that the defendant would have had to believe that Caitlyn was likely to use unlawful force in the commission.
What happened to the? Oh, there it is.
Him. Defense counsel clearly claimed that he was going to use force against, that Caitlyn was going to use force against Ellen. That is not what the law says. It says the actor, the defendant is the actor. So the court should reject that. There's no evidence to support that.
I know that's kind of bizarre.
The state cannot defeat it, and that there's
The last therapist that I went to,
on this issue.
well, I went for my back first, then I went for my shoulder, and I got the same therapist both times. And I was like, nope, that's it. I'm done with this dude. Because I'd ask him a question and he'd go, you want to know the truth? You really want to know the truth? And I wanted to say, dude, I asked you. No, I want you to lie to me. Yes, of course I want to know the truth. Why would you ask me that? And like, I guess he thought it was funny. He would tell me a lie and then tell me the truth. Like he was joking. And I guess he thought it was funny. And so I just quit going. I couldn't afford it anyway. So I was like, I can't afford this. And then when I got my shoulder replacement, I didn't have to go back to that same place. I was like, oh, thank you, Jesus. Because I don't want that therapist ever again. He's just too weird. Oh, that's good. You get a good therapist back. But you don't know
As we state in our motion, interference with
what's
custody
going on
is
though.
not a basis for the use of deadly force.
How do you do that?
The defense is arguing that by telling the defendant or indicating that she wanted to take the children away from the defendant, they are claiming that that is a kidnapping. That is not something that legally Caitlyn could do.
Why do you hate calling them therapists?
To find that would be to add interference with custody.
You're not allowed to call them masseuses anymore. Talk about massage therapists? Her therapist isn't massage though, it's physical therapist.
And with regard to each of the different versions of kidnapping,
My cousin went to school to be a massage therapist, and you're not allowed to call them masseuses anymore because that has a bad connotation now because it's related somehow to Al Capone and the gangsters back in the day or something. Oh, okay.
he may have said, yeah, I had some sort of training. They would have covered that in some of his training. That was an opening for the defendant to say affirmatively and clearly.
How do you turn it into diamonds?
Hostage situation. That's not what he did. He did not say that. So there is no evidence, certainly not evidence at this stage sufficient for dismissal, that the defendant actually and reasonably believed.
I guess it's carbon based, like coal.
And I'll just add in here that ignorance of the law is not an excuse for the defense to claim at this point that, well, the defendant thought that Caitlyn was committing a kidnapping in ignorance of the law, which says that
Yeah.
what she was doing or what he said she was doing was not a kidnapping. The law very clearly says that's not an excuse. The fact that he doesn't know what the elements of kidnapping are is.
That would be cool if I had kids that would want a memento and a memento of me.
Not agree with that. 633.1.1a is the ransom hostage situation. I'm not going to address that any further. 633.1b says that there's a kidnapping of someone confined.
Oh, wow. That is so cool. I didn't know you could do that.
There's no evidence that that's what was happening here, and defense has not claimed that. 1c, to terrorize anyone. Defense has not made that argument. I don't think there's any evidence that Caitlyn was confining Elowen by holding her in her arms for the purpose of terrorizing Elowen or terrorizing the defendant, causing him alarm or dismay. And 633.1.
I have a friend whose fiance died like a month, I think, before they were gonna get married. And her parents, of course, kept like the urn. I mean, his parents kept the urn, but they gave her like a little tiny bottle on a chain. So she had some of his ashes that she wore in a necklace.
But the defendant said it was a combination of things. It was not just because Ms. Naffziger was squeezing her or holding her so hard that she screamed. It was also because of the yelling. So I want to clear that up. So that would be the state's argument with regard to the two murder charges. The elements of those have been met. There is sufficient evidence for the jury to find the defendant guilty beyond reasonable doubt on knowing and second-degree murder charges. There has not been evidence of self-defense sufficient for the burden to shift at this stage for purposes of this argument. Notwithstanding that, there is sufficient evidence, or there is the state of the evidence at this point.
Yeah, that is that. I can't imagine losing your fiance right before the wedding.
To find in the state's favor on the self-defense conduct under 631.3. The elements of that are the defendant engaged in conduct that either placed or may have placed another person.
We always bury our animals in the yard. We have we have like a little pet cemetery.
In this case, the defendant
Although I probably shouldn't call it that.
grabbed Elowen and then
But so our trailer
while holding her so close that she complained instantly.
next door, it's not ours anymore. The front yard of that has a bunch of our pets, but it's way up in the front part of the yard where they don't ever go or use or anything, so it's cool. And then when we moved over here next door, we have them in our backyard. So we don't have markers or anything, but we just know who is buried where.
The defense argument focused on the fact that the defendant is an expert marksman, and there's no way that he would have shot Elowen while he was busy shooting Elowen's mother. That may be true, but in light most favorable to the state, I think it is certainly reckless to shoot a gun that close to a small child while holding her essentially in the other arm. The defense actually presented two factual scenarios here, claiming that maybe Elowen was not in his arms, and that by saying that he grabbed Elowen and ran to the car, she was not somehow in his arms. If that is what
Dang, this is the longest JOA in the history of JOAs.
in the room, not in his arm, not confined, I think that actually adds to the state's case that she's somewhere at large while he's shooting a gun. It is not just the risk of a gunshot wound to Elowen, however, it is the risk of any injury, including injuries to the ear or to Elowen's hearing. There is testimony about that in the light most favorable to the state. The motion should be dismissed at this stage because there is sufficient evidence for the jury to find beyond reasonable doubt for the state. With regard to endangering the welfare of a child, again, there does not need to be actual injury for the defendant to be found guilty. And we are talking about injury to the welfare of a child, not physical injury. The cases on this crime that describe other versions of this, where people have been convicted and those convictions have been held, speak of situations involving, a caretaker getting high or drunk with a child in the car, certainly while driving, but in other instances just getting drunk or falling asleep and becoming inaccessible while a child who is 2 or 4 years old is in the home and unsecured in a crib, walking around in the home where things could happen. Those are factual scenarios that have supported convictions for this crime. The evidence here shows that the defendant shot Elowen's mother in front of her. Although he told the police that he didn't think she saw anything, he hoped she didn't. She told the doctor that mommy and daddy were fighting, daddy hurt mommy and me, and there was a lot of blood. And the light favorable to the state, certainly it is clear that Elowen knows what happened. Elowen is aware that the defendant shot her mother in the head. She was in the room and she saw it. There does not need to be further testimony for there to be evidence.
Okay, I've had enough of this.
That by shooting Caitlyn in the head, the defendant endangered Elowen's welfare.
State versus Burke, 122.
Based on what it feels like. There was no evidence.
Okay, thank you. In response to that.
No, I don't think it's reasonable inference that shooting a child's mother in the head would endanger their welfare.
Okay. Okay, after considering the arguments made by counsel, after considering the evidence that has been produced at this stage of the proceedings, after considering the defense's arguments and the arguments from the state, I'm going to deny the defense motion to dismiss with respect to each of the counts. In construing this motion, the court must construe the evidence in the light most favorable to the state. If there is evidence from which a reasonable jury could infer guilt beyond a reasonable doubt, if there is evidence from which a reasonable jury could infer guilt beyond a reasonable doubt, the motion will be denied, citing State versus Wong, 138, New Hampshire 56, 1993, State versus Burke, 122, New Hampshire 565, 1982, and State versus Reed, 114, 377. Citing from Reed, in order to prevail, the defendant must show that the evidence viewed in its entirety, giving the state the benefit of all reasonable inferences, was insufficient to prove beyond a reasonable doubt that he was guilty of the crime charged. Here, the court does find that the state has produced evidence from which a reasonable jury could infer guilt beyond a reasonable doubt, construing the evidence in the light most favorable to the state. The motion to dismiss is denied. A few comments with respect to the overall ruling. There was a couple points. First of all, I'm going to adopt the reasoning as articulated by the state with regard to the reasons why the court is denying the motion to dismiss. With respect to the arguments from the state, there were a few times when the state inadvertently used the word testimony referring to Mr. Duren as opposed to using the phrase statements. There was a few times when Attorney Spicer used the word statements and a few times when he used the word testimony. Just to clarify, I'm considering the statement of Mr. Duren as referenced in the video and not any testimony, because that was not testimony under oath. So just to clarify, with respect to my reliance upon the arguments advanced by the state, anytime that the word testimony was used, I'm simply substituting the word statement for that as part of the overall argument. With respect to the individual arguments under 627.4, Roman numeral 2, at this point in the proceeding, I would find, once again, at this point in the proceeding, I would find that there has not been evidence relative to subparagraph A or D. There has been some evidence with respect to subparagraph C, and I will even indicate that there has been some evidence with respect to paragraph B, although that would be tenuous. To the extent that the burden has shifted with respect to C and arguably B, I would also find that no reasonable trier of fact could not have found that the defendant, that no reasonable trier of fact could have found that the defendant did not act in self-defense if I'm arguing that double negative correctly under Pennick, I believe it is.
Yes.
Under Pennick, I'm trying to articulate the correct standard to deny the motion to dismiss, indicating that a reasonable jury could find under the no rational jury under the circumstances could not find that the defendant acted in self-defense. It's a difficult standard relative to double and perhaps even triple negatives, but I'm denying the motion on that basis. So I believe that that takes care of the instant motion that is before the court. Attorney Kinney,
Yes, yeah, I think so.
anything further?
No.
Okay. Attorney Spicer, anything further at this time? No. Okay.
I think he's indicating no as to that motion, Your Honor, but we do have an additional
Okay.
motion that I don't know if it's now that the court would like us to renew it.
Okay, one second. Attorney Kinney, any further motions at this point?
No.
Okay. Attorney Duren?
Mayor, at this time, the state is renewing its objection to the proffered testimony or proposed testimony of Brenda Plumundon and/or Shannon Spurgeon. The state notes that despite the court's indication that Ms. Spurgeon's testimony would be cumulative, she has been subpoenaed and is present along with Ms. Plumundon in order to be available for defense testimony. This objection is to any testimony of either of these witnesses related to any plan that they purportedly or reportedly discussed with Caitlyn Naffziger. Your Honor, the court ruled following the state's initial motion to preclude this and following a hearing on that motion that you would allow the testimony, but you further held that Ms. Plumundon would only be able to testify as to her understanding of any such plan or discussion. You indicated that she must focus on the what rather than the why, without being able to testify as to any statements of Caitlyn Naffziger or as to the reasoning behind the discussion or the plan. In making that determination, the court has found that apparently and cited to the court's reading of the defendant's transcript to provide evidence that the defendant was aware that there was a plan between Ms. Plumundon and Ms. Naffziger, and that supposedly that Ms. Plumundon will be testifying to that plan, but the court believed, based on its reading of the transcript and based on some level of a value of fairness, that Mr. Duren was somehow aware of this plan, which even defense has described as a secret plan that the defendant was unaware of. The state, as it's expressed in its motion for reconsideration, believes that there is no indication that the defendant had any knowledge of this plan and that he would need to have knowledge of such a plan or at least of the desired result, in order for this information to be admissible. He would have to know that Ms. Plumunden was involved. He would have to know that the details of what they intended. In its ruling on the state's motion to reconsider, the court made it clear that you were allowing the use of this material in order for the defense to somehow impeach a statement made by the defendant. But the court indicated that it was a statement of the victim that would be impeached, specifically the victim saying she wasn't going to leave. But the state would point out that that victim's statement has only come to the court, been provided to the court through hearsay. It is the defendant's saying that the victim made these words or stated these words, and now the court is allowing the victim's own state of mind in to impeach the defendant's statement about what the victim said. And I hope that wasn't too confusing, but that's what we're left with. Your Honor, with respect to this, essentially the court has found that it would be fundamentally unfair to preclude defense from bringing up a plan that the defendant wasn't aware of to impeach a statement that he says the victim made while she was in his home and right before he shot her. So the court is allowing the testimony, but then further precluding the state from asking questions about the victim's actual state of mind in the 36 hours before her murder. The victim's state of mind is the basis upon which the defendant initially sought admission of this material. But by its own ruling, the court has said Ms. Plumunden can only testify to the what, not the why, and that the court has also precluded the state from talking about the reasoning behind the plan, the basis for the victim's state of mind, which is her statements about her fear, her concern, and the prior relationship that she had with the defendant that made such a plan necessary. Your Honor, the state is cognizant that the victim's state of mind includes potential 404B evidence. It doesn't make it any less admissible to encounter the admission of this plan. Under the arguments that the state has made, the state believes and continues to believe and believes that the evidence that has been provided thus far, including the evidence contained in the defendant's statement, means that the door has been opened. Defense counsel leaned in during their opening statement, indicating about the victim's aggression. They've argued it again in this motion. All evidence of the discussion between Ms. Plumunden and the victim, should the court be allowing any of it, all evidence should be admissible in order to provide the underlying rationale to cure any misleading advantage that the defendant will gain from this information. Again, the defendant had no knowledge of any plan, and this is something that they have now put forth as the actual basis for the defendant both having shot and killed Ms. Naffziger and for the support for these arguments that she was going to kidnap the children and now that she was going to be committing a burglary inside of the home. Your Honor, this is not proper impeachment. It's not proper impeachment of a statement of the victim. It is not proper admission of victim's state of mind evidence. It does not support or corroborate the defendant's state of mind at the time that he shot and killed Ms. Naffziger. Further, with the court striking any discussion or hearsay statements away from the testimony, the admission is not supported by Rule 806, which would be to attack Ms. Naffziger's credibility as to the statement that the defendant told the police she made. Your Honor, in order for then existing state of mind, motive, intent, or plan to come in, this exception does not include a statement to prove a fact, remembered or believed. And that's exactly how this is being used in this instance. It's not only being used to show state of mind, defense is actually intending on relying on it to prove the underlying self-defense claim that they have. That is inappropriate use of state of mind, it is an inappropriate reason for its admission, and with the limitations currently provided, it provides a misleading advantage to the defense that cannot be cured unless the court, if this testimony is allowed, which the state still believes it should not be, but if the court is allowing any of it, it's still the state's position that the door is open and that the state should be allowed to elicit any and all testimony of Ms. Plumunden with respect to the planning of this situation. And so the state renews its objection, renews its motion to preclude, and renews its motion to reconsider.
Okay, thank you, Attorney Duren. Attorney Kittle?
Yes, Judge. I would reiterate all the arguments made in our objection. written objection in our previous argument on this hearing, on this motion, and in our argument on the state's motion to reconsider, as well as the court's prior ruling. The court has ruled on this issue twice. There's been no new information, no change in the information available to the court when it made its ruling. A second motion to reconsider at this stage is not proper. The court's ruling is sound. This evidence is admissible under 8033, and because a reasonable inference can be drawn, as we've discussed at length previously, that Mr. Duren was aware of the plan. I'll note a couple of things. I think that the state is misciting 8033. 8033 allows a statement of the declarant's then existing state of mind, such as plan, but not including a statement of memory or belief to prove the fact remembered or believed. So if we were trying to introduce some statement about a past tense plan, something that like a statement that was made to Ms. Plumundon about events from months ago, then that would not be admissible under 8033. But because it's Ms. Plumundon's testimony about a current plan, it does apply under 8033. I'll just note a couple additional things. Again, this has been litigated at length. We've relied on the court's ruling. The court's ruling is sound. But the state argued a few moments ago that the kidnapping is a fabrication of the defense. I would expect they would argue that in closing, and the kidnapping is not a fabrication of the defense. Ms. Naffziger had this plan. Ms. Plumundon has told that to detectives, to our investigator. She sent a text saying you need to help plan a kidnapping. And so if the state's going to argue that kidnapping is a fabrication of the defense, that's certainly a problem when there's evidence that that's not the case. The other thing I'll note is the state, I'll rely largely on prior arguments on opening the door, but the state said the door has been opened because there's been evidence of Ms. Naffziger's aggression. The state introduced that statement. The state pressed play on a video that had a statement about Ms. Naffziger's statement, and the state cannot open its own door. So the court's prior ruling should stand.
Okay. Attorney Duren, any response?
No, Your Honor.
Okay. Satisfied with the record relative to those issues?
Yes, Your Honor.
Okay. All right. I'm going to deny the state's motion to reconsider on that aspect. I ruled several times on this matter. I did rule that Ms. Spurgeon would be inadmissible, would be excluded.
Oh, yes, Your Honor. I'm going to be calling Brenda, so I'll talk to the court a little bit about that. Miss Brenda Plumundon is our witness, but Miss Spurgeon, Trooper Pratt, Arthur Booten are all here in case we need to call them for rebuttal purposes. I do have a request before Miss Plumundon comes in, Your Honor, but it's about her testimony. But it's appropriate.
And I'm just going over my notes relative to the state's.
Defense wants to call Brenda, the person that she was supposed to be staying with. And the state is
Again, I'm
objecting.
going to restate part of the basis for my ruling is I believe that the state, in introducing the statement of Mr. Duren through Sergeant McLaughlin, it is clear that at several points in that statement, Mr. Duren referenced a plan. He wasn't sure of what was happening. He articulated several times, and I recognize that he was offering the statement to law enforcement at the time after he had a period of time between the event in question and the time of his interview. Not a lot of time, but there was some time. I recognize that he was offering the statement and that he indicated to law enforcement that he was asking what was the plan as it relates to Ms. Naffziger being retrieved, so to speak, from his apartment in Berlin. In other words, was he going to bring her back to Hampton? Was someone else going to pick her up? there was a number of times in which Mr. Duren was asking what was happening to Ms. Naffziger, according to his version of events. And based upon the defense argument relative to the introduction of Ms. Plumond, am I pronouncing it correctly? Plumondon?
I believe so.
Okay, I apologize if I mispronounce. But according to that, I'm allowing the defendant to bring her in to testify relative to the contours of that plan, not with respect to any individual hearsay statements of Ms. Naffziger.
Oh,
and not with
you
respect
opened the
to
door,
reasons
State.
for it. I agree with the defendant relative to the 404B motion that was previously ruled upon as it relates to any conduct that is not currently before the court. And I don't think that the door has been opened. I agree with Attorney Kettles as it relates to the fact that the state cannot open the door itself. Whether that happens during the rest of the trial remains to be seen. That'll be subject to further discussion as we move forward. But as of right now, the purposes and the reasons behind my ruling still stand. Anything further, Attorney Duran, on those points?
No, Your Honor.
Okay. Attorney Kitty.
Yes, Your Honor, thank you. So, Ms. Plumondon is here. Well, I believe she is. I haven't seen her today, but, okay. And she is prepared to testify. We expect her to be a hostile witness. This is difficult, I'm sure. Her family is here, has been here. And we are very concerned that something might be said to cause a mistrial. So I'm asking for two things. Number one, for the court to have a colloquy with her outside the presence of the jury to just let her know she's answering the questions that are asked and not going into details. Because I think there will be a desire, a natural desire to try to explain things. And I would like to be able to lead a very tight and specific questions to.
So you want to treat her like a hostile witness. You want to cross her.
Admissible.
You want to lead her.
That the state got to do that with Carolyn Campbell. We want to avoid a mistrial, and I think that the chances are high that she will say something. And I haven't been able to talk to her about that, but I also don't know how much weight she'll give me saying those things. I think it would be better to come from the court.
Okay, thank you.
Your Honor, it's unclear to the state whether defense has actually spoken to or prepared Ms. Plumondon for trial testimony at all, let alone where this indication is that she's a hostile witness. Ms. Plumondon is here. She was provided with, I guess, Mr. Booten's report as far as I saw. She described it as a transcript when we were told what she received. That's all I know. It looked like Mr. Booten's report. I haven't spoken with Ms. Plumondon because she's a sequestered witness, but she's being called by defense. I'm not sure that they've spoken to her. It became clear during a chambers conference yesterday that they hadn't spoken to her about sequestration. And so I don't know how we're at the point now of saying she's going to be hostile. Defense counsel is calling her as a witness. They didn't take an opportunity to prepare her. And now they're attempting to say that she's hostile. There's no indication of that at this time, Your Honor. She's not a party to the case. Sure, her family is here. Yes, she has a relationship. Her niece was murdered. But that doesn't mean that she's a hostile witness in any way, shape, or form. I understand the defendant's concern, and I will note that the state was ordered to lead Ms. Campbell through testimony because of objections made by defense. Ms. Campbell wasn't a hostile witness in any way, shape, or form. Defense wanted to limit her testimony because they didn't want her talking about hearsay statements that, again, the state doesn't believe were inadmissible hearsay. They were her descriptions of her actions. There's no indication that Ms. Plumondon is hostile. There's no indication of anything at this point. She's just a subpoenaed witness that hasn't been prepared by the people calling her.
Your Honor, first, we got a Zwicker letter the other day from the state, so someone talked to her. But the consideration...
If I may interrupt really quickly, the Zwicker letter says Ms. Plumondon was asked 2 questions and provided the answers to those 2 specific questions, and that is it.
Okay, so you talked to her, though.
2 questions. What was Valen's date of birth? I do not know. was Caitlyn Naffziger breastfeeding? No. Those were the questions.
611 to C2.
That's what I'm looking at.
Okay.
What are you barking at?
Party or a witness identified with an adverse party. And it is true that I have not specifically talked to Ms. Clemunden about her testimony. I have provided her the recording of her 2 statements that she gave to the police on March 1st and March 15th. I have provided her the transcripts of both of those calls. I have given her the report that Arthur Booten typed up of his interview with her. Those are what she has. I have not talked to her. I have given her the opportunity to ask me questions. But based on what she told the police on March 1st and March 15th and Arthur Booten, and the things that she said about the defendant and the reasons why the plan existed, it's very prejudicial. It will lead to a mistrial if it gets blurted out, Your Honor. So for that, there's 2 reasons that I'm asking the court to give a colloquy to her and allow us to leave so we can avoid that. And it would be great if she doesn't come off as a hostile witness and just gives, and would give us the information. I just think the risk is very high, and to avoid future litigation, I am asking that we be allowed to do that.
Okay. Understanding that there's issues relative to the preparation of witnesses and disclosures of various information, understanding that, Attorney Duren, do you have any specific response to those 2 specific requests by the defendant?
Your Honor, I'll defer to the court.
Okay, all right, thank you. Okay, I think under the circumstances, I'm going to grant the defendant's motion to allow leading questions relative to this witness, and I will conduct a brief colloquy with her because of the reasons stated by defense counsel relative to those issues. The colloquy is going to be focused upon her understanding that she has been number one, that she has been subpoenaed here, and that she's going to be asked questions, and that she's instructed to, is she prepared to answer the question that she is asked? Are you prepared to answer the question that you are asked? And are you prepared to limit your testimony to the question that was asked and not to volunteer further information? Is that sufficient, Attorney Kenny?
And I think it would also make sense to instruct her specifically in accordance with your order that we're talking about the what of the plan and not the why of the plan.
And finally, that she's not to testify about statements allegedly made by Caitlyn. That she can testify as to her perception, her understanding of what her understanding of.
Just a question for clarification as to why the state has asked so many times for the motion to be reconsidered. Is Ms. Clemunden then allowed to testify to the factual result of a statement that is a hearsay statement of Ms. Naffziger, or is she only allowed to testify to her portion of the plan?
Her understanding of what was going to happen.
And doesn't that include hearsay statements of Ms. Naffziger?
And I've already ruled that relates to her understanding as to that, not relative to indirect hearsay. But she can't testify as to what Caitlyn said to her, but she can testify as to what she understood the plan to be.
Did you finish? Did you talk?
Anything further, Attorney Kenny?
No, Your Honor.
Okay. Attorney Duren, anything further right now?
No, Your Honor.
Okay. 10-minute break.
Thank you.
Okay. questions of me, ma'am? The attorneys for the state will have the opportunity to ask. Being here. Good morning. Thank you. Please be seated. Okay, we're back on the record outside the presence of the jury. Good morning, Ms. Palondon. Am I pronouncing that correctly?
Yes.
First thing, Ms. Palondon, if I could have you raise your right hand, please. Do you swear that any testimony you give today will be the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
Yes.
Okay, thank you. Can I ask you to please spell your last name for the record, please?
Plamondon.
Thank you. Again, thank you for being here. I understand it's under subpoena. Have you spoken with Attorney Kinney about the scope of your testimony?
No.
Okay. Ms. Palondon, I am allowing the defense attorney to call you as a witness in this matter, but I have placed significant limits on the scope of your testimony. Okay? And has anybody told you that?
The defense attorneys just let me know that a minute ago.
Okay, all right. I'm going to go over that with you now in an effort to just make sure that we're on the same page before the jury comes back in.
Okay.
Okay, thank you. When Attorney Kinney, the lawyer for the defendant, when Attorney Kinney asks you a question, are you prepared to answer the question that was asked by Attorney Kinney?
Yes.
And when you answer her questions, are you prepared when testifying to not volunteer further information other than what you were asked about?
Yes.
Okay, thank you. Now, I want to also let you know that the state will have the opportunity, when Attorney Kinney is done, the attorneys for the state will have the opportunity to ask you questions as well. So that may clarify some of what you are asked by Attorney Kinney, but they will be operating under the same orders and rules that I have put in place relative to what they can and can't ask you. So it's not just Attorney Kinney asking you questions. The state will have the right to ask you questions as well. Okay?
Okay.
Okay. And Ms. Palondon, the questions are going to be based upon what you knew at certain points in time. Okay? They're not going to be based on why you knew them. In other words, it's not based upon what Caitlyn told you or why certain things were being done. It is limited to what you knew at the time.
Okay.
Okay, in other words, your knowledge as to what was happening at certain points in time. That is what your anticipated testimony will be, at least with respect to the questions being asked by Attorney Kinney.
Okay.
Okay? Specifically, it will be about what you understood, your personal understanding as to any plan that you might have had with Caitlyn.
Okay.
Okay? It doesn't include Caitlyn's specific statements to you as much as it is what you understood the plan to be.
Okay.
Okay? In other words, it's limited to your understanding at certain points in time. And I understand it's difficult on many levels. I'm simply going over what the court's expectations are at this time. Do you have any questions of me, ma'am?
No, I understand.
Okay. And at this point, Attorney Kinney, any further comments or inquiry by the court that you would request?
No, none, Your Honor.
Okay. Any from the state at this time, Attorney Duren?
Nothing.
Okay. So I'm going to bring the jury in, and once again, if you have any questions of me, I realize this is a difficult process. If you have any questions of me, we can try to go over them now. I'll give you just a moment.
If there's a word or some no answer, then if
Just answer honestly, answer the question that Attorney Kinney or the attorneys from the state ask you. Just answer honestly to the best of your ability and to the best of your understanding as to what you understood at the time relative to any plan with Caitlyn.
okay.
Okay? I appreciate your ability to follow the court's instructions. Okay? Thank you.
Yes.
She seems pretty reasonable to me. I don't think she's going to be a hostile witness. I understand why they said that, though. I mean, if Brenda was her friend and this guy killed her, yeah. But I think she's going to be reasonable. She seems like it.
Sure, thank you.
All rise for the honorable jury. Cook County Superior Court is now in session. The Honorable Jonathan S. Frizzell presiding.
Okay, thank you. Please be seated. Ms. Plumon, if I could have you raise your right hand. Do you swear that any testimony you give today will be the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
I do.
Okay, if I could have you state your name, please, and spell your last name for the record.
Brenda Plamondon, Plamondon.
Thank you.
Good morning, Ms. London. I just have a few questions for you. You live in New Hampshire,
Yes.
and you have 2 children?
3.
3 children. And Caitlyn Naffziger was your niece by marriage?
Yes.
Okay. And Elwyn and Valen are her daughters?
Yes.
They never lived with you though, correct?
No.
Oh, family, not friend.
In early of 2024, Caitlyn reached out to you about coming to visit?
Yes.
And she didn't give you much detail about her visit at that point, right?
Yes.
So yes, she did not give you detail?
She did not give me much detail.
Okay, thank you. And in later February, she reached out again with information that she was going to come to New Hampshire.
Yes.
Okay. And you knew that she had a plane ticket to Boston, correct?
Yes.
And that she was bringing the baby Valen with her, correct?
Yes.
But you didn't know where she was going to stay, right? Before she got to Boston?
Yes, that's true.
Okay. Or if she needed to borrow a car, right?
Right. I had offered.
You had offered, but you weren't sure. She never responded yes or no, right?
True.
Okay. But Caitlyn and Valen did come to Boston in late February 2024, correct?
Yes.
And they stayed with you the first night they arrived
Yes.
in Hampton?
Yes.
Okay. And you and Caitlyn and Valen stayed the night in Hampton. Was anyone else there?
Yes.
Is that Shannon
Yes. And my husband, Mark.
and your husband, Mark? Shannon is your friend?
Yes.
So that night at your home was the first time you really got to talk to Caitlyn about her visit to New Hampshire, correct?
Yes.
Okay. And that Caitlyn was there, her plan was to go up and get Elwyn and go back with both kids to Minnesota, correct?
Yes.
Okay. And so you and Shannon and Caitlyn talked about how that plan would play out, correct?
Yes.
Okay. And you knew that Caitlyn had a return ticket to Minnesota, correct?
Yes.
And you would offer to pay for Ellen's ticket back?
Yes.
Okay. So the plan was that Caitlyn and Vela would go up to Dustin's in Berlin and study his habits, right?
Objection.
No. Sorry.
Approach Adam. Back in March of 2024 about this case, correct?
Yes.
Okay, and that was a recorded phone call that you gave them?
Yes.
And you agreed to be recorded?
Yes.
And you told them everything that you knew at the time, correct?
Yes.
And you didn't leave anything out?
To the best of my knowledge.
Okay. And you had a chance to look at the transcript of that recording, correct?
Yes.
Okay. And I'm going
Hey.
to show you page.
Did I miss
7.
something? Hang on.
Transcript. Back in March of 2024 about. Night at your home was the first time you really got to talk to Caitlyn about her visit to New Hampshire, correct?
Yes.
Okay. And that Caitlyn was there, her plan was to go up and get Elwyn and go back with both kids to Minnesota, correct?
Yes.
Okay. And so you and Shannon and Caitlyn talked about how that plan would play out, correct?
Yes.
Okay. And you knew that Caitlyn had a return ticket to Minnesota, correct?
Yes.
And you would offer to pay for Elwyn's ticket back?
Yes.
Okay. So the plan was that Caitlyn and Vela would go up to Dustin's in Berlin and study his habits, right?
Objection.
No. Sorry.
Approach Adam. Back in March of 2024 about this. So, Ms. London, the plan was for you, if you had not heard from Caitlyn on Saturday, you were going to go to Berlin and wait at a restaurant to leave with her and the kids, correct?
No.
You spoke to the police back in March of 2024 about this case, correct?
Yes.
Okay, and that was a recorded phone call that you gave them?
Yes.
And you agreed to be recorded?
Yes.
And you told them everything that you knew at the time, correct?
Yes.
And you didn't leave anything out?
To the best of my knowledge.
Okay. And you had a chance to look at the transcript of that recording, correct?
Yes.
Okay. Of your transcript. Where you say line
assume it's-
9,
I assume it's being used to refresh your recollection.
I'm impeaching her, Your Honor.
Your objection.
Yes. So the question was that first question that got objected to was you and Caitlyn were supposed to go up there to observe his habits, which she said no to. The next question was, well, if you hadn't heard from her, you were supposed to go wait for her at a restaurant and pick up her and the kids, and she said no. So already 2 of the questions that she wanted a yes to were answered in the negative. And then now there's a phone call that was wiretapped by the police, and she's trying to show her the transcript to refresh her memory, and now the state has objected to that. They weren't doing it right, but it's no reason to go up to the bench.
Fair, and does it look like this? Does the copy that you were given look like this?
What is this defense exhibit, what?
ID, D.
Thank you.
I don't know, it was an email.
Okay, well, why don't you take a look at that and let me know if that looks, item review.
Yes,
And is that a fair and accurate, transcript of what you told the troopers in March of 2015, March 15, 2024?
some of it was mislabeled of what Shannon said and what I said.
Okay. And so I also have clips. Were you able to listen to the video?
No.
Okay. So, Your Honor, can we approach?
Yes.
I thought she was supposed to stay with Brenda. Who is Shannon? The phone call was between Brenda and Shannon that the cops wiretapped. Who is Shannon?
Okay.
So, again, the plan was to go to Berlin and wait for Caitlyn and the girls to come meet you at a restaurant or somewhere and take them back to the airport.
No.
Okay, so can you tell us what the plan was?
That we were waiting for Caitlyn to call us and tell us how she needed a ride and that we would meet her wherever we needed to meet her. And if by Saturday we hadn't heard from her, that we were just going to go to Berlin and wait to hear from her so that we would be closer and ready.
Isn't that kind of what that
And the
woman just
plan
said?
was to get them back to Minnesota, all three, Caitlyn, Valen, and Elwin, as quickly as possible.
Yes,
The next day, after that plan was discussed, you offered to drive Caitlyn and Valen up to meet Dustin, correct?
kind of.
Okay. Did you drive her up to Ossipee?
Yes,
Okay. And you drove with Shannon, Caitlyn, and Valen, correct?
yes,
Okay. And you drove Caitlyn and Valen to the designated meeting place, which was a restaurant in Ossipee, correct?
yes,
Okay. And Caitlyn brought a suitcase with her, correct?
yes,
She had a bag of like wet laundry because there was an issue with the dryer.
yes,
Okay. But she did leave behind other things, right? Like her backpack,
yes,
kids' birth certificates.
yes.
Would you like a break?
Heartless cameraman, why did you need to do that?
Okay,
Okay. I only have 3 more questions. You didn't see Dustin or Elwin when you dropped Caitlyn Valen off, right?
no,
And after you dropped them off, you called Caitlyn's mom to tell her what the plan was, right?
no,
Okay, you called folks though to talk to them?
yes,
Okay. Those folks being her mom
yes,
and her dad, Rob?
yes.
Okay. I don't have any more questions, thank you. Where's the building?
I don't hear the clock today.
You're welcome, sir. Okay,
Yep,
there's some water there. Do you have some?
yep,
Okay, do you need to take a minute?
nope, I'm okay.
Okay. Ms. Plumundan, you live in Hampton, New Hampshire, correct?
Yes.
How long of a drive did you have to come to court?
I don't know, like 2.5 hours, I think?
Are you familiar with this part of the state?
No, I'm not.
Had you ever been to Berlin, New Hampshire before?
No,
Have you still to this day been to Berlin, New Hampshire?
I have not.
Now, Caitlyn Naffziger, she flew from Minnesota to Boston on February 27th of 2024, right?
Yes,
And then she took a bus to New Hampshire?
yes,
And then you and/or Shannon picked her up from the bus stop?
yes,
She and Valen, her youngest child, they spent one night with you in Hampton, correct?
yes.
Can you tell us during that time, did you have a chance to observe Caitlyn and Valen together?
Yes.
Without telling us what anyone said, what were your observations of their relationship?
What a good mom she was, and how relaxed the relationship was, and just how happy she was. Both of them.
Had Caitlyn ever come to see you in New Hampshire before?
Yes,
How many times?
At least 3, maybe more.
How long had it been since the last time she'd been here?
We have a holiday called Thanksmas, and she,
Thanksmas?
yes, and we
Okay.
do everything that we've always done, Christmas to Thanksgiving in 1 week, and all the family gets together. And so she was there for that, as was her mom and husband and other family members.
Her mom's husband?
Mhm. Yeah, her mom Lori and,
Okay. Just making sure I know
yep,
who you're
yep,
talking
and
about.
Lori's husband Tim and my kids, and
Had Caitlyn ever been to Berlin, New Hampshire?
no,
Not before February of 2024?
no,
Did she have any friends in New Hampshire?
no,
Were you her only relative in New Hampshire?
yes,
Besides her husband as well, right?
yes, yes,
And your kids?
yep,
And you, and I don't mean this to sound improper, but you're related to Caitlyn by marriage, correct?
yes.
Now, on February, when did she get there on the 27th? In the morning? Or was it nighttime?
It was evening, and I was working and coming from Boston, so I didn't see her until like 5 p.m.
Okay. So at some point, sounds like less than about, I don't know, less than a day later, you drove Caitlyn to that restaurant in Ossipee, New Hampshire, correct?
Yes,
A place called Harley Jack's?
yes,
Does it take, fair to say it took you over an hour to get there?
yes,
Had you ever heard of it before?
no,
Ever been there?
no,
When you got to Ossipee at Harley Jack's restaurant, Caitlyn got out of the car?
yes,
She took Valen out of the car?
yes.
Was Valen in a car seat?
Yes, it was like a car seat that fits into the stroller.
One of
Okay.
those like dual, like
Right.
pop it in and out things.
Right, but
Okay.
she left the stroller portion at my house.
Okay. You didn't go inside the restaurant, right?
No,
When Caitlyn got out of your car and took Valen, without telling us what she said or did what she said, how was she behaving?
I mean, it was quite a sad sight, and Shannon and I both cried. You know, she's such a small person, and she had this big, enormous suitcase, and, you know, she had the baby in the car seat, and she was just like lugging it. I felt awful for leaving her there.
But you did leave.
Yes, she specifically asked that we not come in because,
Hearsay.
So you left.
yes,
Okay. You didn't see the defendant at Harley Jack's?
no,
And just so we're clear, do you know the defendant?
yes.
How do you know him?
We have FaceTimed many times, and I, know him as the father of Valen and Elowen, and because of Caitlyn's relationship with him.
You didn't talk to the defendant when when Caitlyn was in New Hampshire, correct?
No,
You didn't talk to him in Ossipee in the parking lot?
no,
You didn't talk to him over the phone after you left Caitlyn in the parking lot?
I don't even have his contact information.
He didn't speak to you?
No,
Did you leave before Caitlyn went in, or did you watch her go in?
we left as we parked far away in the parking lot and left as she was walking through the parking lot.
So you didn't wait in the parking lot until they finished lunch and left the restaurant, did you?
No, I had no
Yes.
contact after she got out of the car.
And when you left the parking lot at Harley Jack's, where'd you go?
Home,
Okay, so you drove the hour back to Hampton?
yes.
You didn't follow them back to Berlin?
No, I was working, and it was 5 o'clock, so Shannon had driven up there, but now I was done working and I shut my laptop and I'm like, oh, I can drive home. And she's like, great, because I don't see well at night. So,
So you wanted to get home.
yeah,
You'd agree that your home is at least 2.5 hours away from Berlin?
yes.
Now, what defense has asked you about in terms of this plan is that you were going to, the plan was for you to go up and sit at a restaurant on Saturday, correct?
If we hadn't heard from her at that point.
Okay. Did there ever come a time that you heard from Caitlyn?
No,
When you dropped her off in the restaurant parking lot, was that the last time you saw her?
yes,
As part of the plan, did you choose a safe word?
yes,
What was the safe word?
that
Your Honor, can we approach?
Called it a code word, correct?
I don't recall.
And if you got this code word, you were gonna drive 2.5 hours? Is that fair to say?
And call 911.
Was part of this plan to tell the defendant about it? Would that have made sense to you?
About the
tell him?
code word?
Nope, to tell him about the plan in general.
No,
Was Caitlyn gonna tell him about it?
no,
Was your plan designed to hurt Elowen?
no,
Was your plan designed to harm either child?
no,
Was any part of the plan to seek money?
no,
Was there any part of the plan that had Caitlyn telling the defendant that she was gonna call the police to take custody of the children?
no,
Was there any part of this plan that required Caitlyn to tell the defendant that she was gonna take the children back to Minnesota?
no,
Did Caitlyn have a car with her?
nope,
Did she have a rental car reservation anywhere?
no,
Did she have a bus ticket?
no,
Was Caitlyn familiar in any way with the area in Berlin, New Hampshire?
no,
And the plan was that she would have the 2 children with her, correct?
yes,
Caitlyn never texted you to say that she got into the restaurant okay?
no,
She never texted you to say the defendant was there?
no. She specifically said she couldn't text because he would control her phone.
She didn't call you to say that they were leaving the restaurant?
No,
Did she send you any?
I don't like the defense attorneys. Why can't they just object like a normal attorney? Why do they have to say approach every time? Good Lord. Seriously, people?
Relative to controlling the phone, and I instruct you to give it no weight whatsoever.
She didn't call you to say that they left the restaurant, correct?
no, she did not.
Did she send you any photographs of her with the 2 children?
Why?
No,
Did she text you at any time and say, help, please come?
no,
Okay, prosecutors too
Did she
then.
ever text you a code word?
no,
Did there ever come a time that you heard from Caitlyn after you dropped her in that parking lot in Ossipee?
nope,
that part of the plan?
No,
Any other questions?
Ms. London, part of the plan was for Caitlyn to take both children while Dustin was asleep, correct?
no,
That, you didn't discuss how he plays video games, it stays up all night?
Objection, you're not outside the scope.
Approach, Your Honor.
Good Lord. Well, you can object with a grounds and then they can sustain or overrule. Then, if you want to argue it, you can say, may we approach? You don't have to argue it every single time. That wastes time.
As part of your overall considerations, and you may rephrase.
Thank you. Ms. London, is it fair to say that the plan was for Caitlyn to get the girls from the apartment and leave without Dustin knowing?
yes,
Thank you. No more questions.
Okay. What now? More questions.
Ms. Plumenden? You've just testified that the plan was for Caitlyn to leave with the two girls, correct?
yes,
Without the defendant knowing.
yes,
Caitlyn did not have a car,
right,
did not have a bus ticket,
right,
did not know the area.
right,
You were 2.5 hours away.
yes,
She didn't know anyone else in the state.
no,
It was February in Berlin, New Hampshire.
yes,
Fair to say the temperatures range between -2 and 32.
yes,
Fair to say that it was snowing that week.
This is beyond the scope.
Overruled.
I don't recall.
Okay. I have no further questions.
Okay, counsel approach, please.
Well, he asked them to approach that time. Good gravy, Marie. Well, I don't like the judge either. This whole trial is being done at sidebar.
Yes. Early, and so we will break now. We are going to reconvene at 12:45. I'll expect you folks back at 12:45. I will meet with the lawyers before that, but I would ask that you be ready to go at 12:45. It is currently 11:30. Again, consistent with all of my instructions, do not discuss the case amongst yourselves or with anyone else. Conduct no research. as to any matter. Don't transmit any matter through your own social media. And if you see someone in Lancaster, please don't talk to them. But other than that, thank you for following my instructions, and we'll reconvene again at 12:45. Thank you.
All right.
Than the lawyers, I'll just confirm that what I've indicated is we will reconvene court at 12:30. I know that I indicated that the jury to be back at 12:45, but my expectation will be to confer again with the attorneys at 12:30, and the court will be in recess from now until 12:30. Is that sufficient, counsel? Sufficient? Okay, all right, thank you. Court will be in recess.
Okay. Well, 12:30. Or 12:45. I guess 12:45. Because we're probably not going to be able to hear anything they say at 12:30 anyway. So, 12:45, guys. I will see you back at 12:45. Enjoy your lunch. Have a good one. Please join me again. If not, I will see you guys Monday if you can't join us for the afternoon session. Have a great weekend. I will see you Monday morning. Bye, guys.